All right, we're going to do this one a little bit out of order. We're going to do chapter 20 right now. So, chapter 20, transfer of title. In this chapter, we're going to describe the four methods of title transfer and explain the process of transferring of title of a deceased person's property. So, the word title means ownership of the land, and alienation is a transfer of title to a parcel of real estate. And this can be done during someone's lifetime or after their death. It can be done voluntarily, that's something they wanted, or it could be involuntary, something that they had no choice in. At death, voluntary alienation is done through a will, or involuntarily if no will was left, because the state will then get it through the process of escheat if no heirs can be located and you died without a will, naming any devisees. So, title to real estate means the right to or ownership of the land. Let's highlight that. And then I want you to write in here alienation, the transfer of title to a parcel of real estate. All right, everybody got that? So, voluntary alienation of title can be done by gift, sale, or exchange. The owners use some form of deed to convey their ownership during their lifetime, or by a will to transfer voluntarily upon your death. Transfer of ownership to or from the government would be dedication. Dedication is when you give land to the government for a public use like streets, schools, and parks. Unfortunately, there's no one liner that we're going to have you highlight in the book here. So I guess at some point we can write this in somewhere. And public grants is when government gives public land to an individual for private use. They could grant you that ownership, whether they give it to you or sell it to you. All right, you all good? So let's highlight the voluntary alienation. Um, I guess they have ownership of subdivided lands earmarked for streets, roads, or municipality through the process of dedication. Um, it's not that clear, but it's giving land to the government for the public use, like streets, schools, and parks. They wrote it as ownership of subdivided lands earmarked for streets, roads to a municipality through the process of dedication. All right. And lands owned by government may be transferred to individuals through public grant. Okay, so you're highlighting here what voluntary alienation is. You're highlighting that. You're highlighting involuntary alienation. And when a person dies intestate and leaves no heirs, title to their real estate passes to the state by escheat. All right. Everybody good? Everybody got it? Yeah. So here we go. Involuntary alienation is the transfer of the without the owner's consent. Transfer of ownership without the owner's consent. That can be done by escheat or by eminent domain or by foreclosure when you have unpaid debts like taxes or mortgage loans. By a court action through a partition proceeding or suit to quiet title. Through adverse possession with an easement by prescription that must be perfected with a suit for adverse possession. This is also known as squatters' rights by some. Or by erosion by Mother Nature. Sometimes she takes away your land. A decrease in land caused by the wearing away of land by the wind or water. So let's highlight on the page 375, second paragraph. A partition proceeding is one where a co-owner seeks to force another to divide or sell their property. All right. Here we got a little guide here. Let's see. The action, the process, and who takes the property. The action, when a person dies intestate and no heirs can be located through the process of escheat, the state takes it. If the land is needed for a public use, through eminent domain and a condemnation hearing, when the owner is justly compensated, the public or governmental agency or quasi-governmental agency or land clearance commission or public utility company actually gets the property. Through non-payment of a debt secured by real property, the process in New Jersey is known as foreclosure, and in New Jersey, it is a judicial process. It has to go through the court systems. Then the sheriff sells the property to the highest bidder. And through the open, notorious, continuous, hostile, and adverse use of another person's property for a prescriptive period of time as prescribed by law, an easement by prescription is used for adverse possession, also known as a suit for adverse possession, and then the adverse possessor gains ownership if they're lucky enough to win it and prove it. So, in a partition proceeding, one co-owner seeks to force another to divide or sell the property. You guys already highlighted that, didn't you? Here's a slide I put together about adverse possession and how to perfect an easement by prescription. So an easement by prescription is known as squatters' rights or adverse possession. We're going to go over it in chapter 6, I think, 6 or 7. But we're also going over it here in chapter 20. When you use someone else's property for a period of time as defined or prescribed by state law, you could claim ownership of that property that's being used. Now, to perfect this easement by prescription, it requires a court action called a suit for adverse possession or suit to quiet title to claim ownership of the land. The use had to have been continuous, hostile, adverse to the owner's title, exclusive, and without the owner's approval. Additionally, the use must be visible, open, and notorious. The prescriptive period in New Jersey is 30 years for improved lands and 60 years for unimproved lands before you could make a claim of adverse possession to get the ownership, or before you could successfully gain adverse possession, not in order to make the claim. So this law will be changed at some time in the future to 20 years. So both the 30-year and the 60-year prescriptive period will be changed to the common law 20-year period. currently, nobody's going to win a case for adverse possession in New Jersey, because for the last, I think it's 17 years, as long as I've been following it, New Jersey politicians had this legislation sitting on their desk waiting to vote on. They know what they want to vote on. They just haven't voted on it yet for this long of a period of time to change these laws, because our politicians made too many laws that cover the same topic. You got the common law period, which is 20 years. That's already on the books. You got 30-year for improved lands, and then they created another law that's a 60-year period for unimproved lands. And because there's all these different time periods, they conflict with each other with the 20-year period. And therefore, nobody's going to successfully win a case for adverse possession in New Jersey until the politicians clear it up. And about 17 years ago, one company sued another because they claimed that they've been using their land for over 60 years. And the other company's defense was, yeah, but the law says that you need to file the complaint within 20 years. Their argument was, yeah, but we can't successfully win an adverse possession claim until we've possessed it for 60 years. They said, well, how's that our problem? You got one law that says 20 years and another one that says that one law says you got to file the complaint within 20 years, and another one that says the only way you'll win the complaint is if you used it for 60. So the judge did the right thing in this case. Instead of legislating from the bench, which some judges sometimes do, and that causes future problems, they set a precedent and basically a de facto law. And that's not the judge's job to create laws. Politicians create the laws, and judges interpret them and rule on them. So because there's the conflict, because too many laws have been created in New Jersey for this topic, the judge kicked it out and back to the politicians to fix their own problem that they created. So he did not rule on this case. Said, I can't rule on this case. I can only interpret the law. I cannot create a de facto law by legislating from the bench. And if I ruled on one way or the other here, I would be creating a law. So he kicked it back to the politicians, and the politicians went and sorted it out, and they did their legislation, and they figured out what they want to do is do away with the 30-year period and the 60-year period and stick with the 20-year common law period. But they haven't did the final vote on it yet. It's just been sitting out there for the last 17 years. You know, if they want to create a new gas tax in New Jersey, how long does that take? What, 30 days? But they created this problem by writing too many laws on the same topic, creating a conflict, and that created a problem. So the judge actually did the right thing here by pushing that back on the legislature. Now, through the process of tacking, successors in interest, like a landlord and a tenant, or an ancestor and their heir, or a seller and a buyer, can add one person's time of possession onto another, combining them to reach the prescriptive period that's required to successfully claim an adverse possession claim. Now, we know that there are 3 conflicting laws here on the books, and I told you that it's going to be changed to the 20-year common law period. But currently, for exams, even these books, if you look at the last several issues of these books for the last bunch of years, the book manufacturers are even confused about it, the way they write it in the book. So on exams, the current laws still in place go with the 30 years for improved lands and 60 years for unimproved lands when you get a question about this on exam, about claiming adverse possession. Okay. Now, how could you prevent somebody from successfully taking your property by adverse possession? Well, any owner of real estate should walk on their property and check to make sure that nobody is squatting on it and take action against any adverse possessor to get them removed from their property as soon as possible, at least once every 30 years, or if it's improved lands, or at least once every 60 years if it's woodlands. So an owner can take legal action against any adverse possessor to get them removed, or they could cut off their access. This stops the continuous use and resets the time clock for the prescriptive period. All you got to do is interrupt it for 1 day, and then it's not continuous. Or they could give them permission. You can't claim adverse possession if the owner gave you permission to use their land. And a little note I put there at the bottom: an easement by prescription cannot be claimed against publicly owned land, only against privately owned land. All right. So let's do some highlights here on page 375 about adverse possession. Now they have an additional thing while you're highlighting. I'll just read it to you. It says, once adverse user has established title, the former owner has no recourse. So to prevent such loss of title, every person having the right or title to real estate must inspect their property at least once every 30-year period and take action against any adverse claims. And although this is not on exam, at the bottom, I put a little bracket around it, and it's interesting to read. I actually used this a couple times to explain to people to keep them out of trouble, including one mayor of a town. I gave them some advice. They're trying to strong arm some property owners, and or one property owner in particular, who she owns a lot of land, and I gave them some advice on what not to do because it could backfire on them. Now, property owners who feel that new government requirements have taken away their rights because they put in so much zoning laws and other kinds of governmental red tape on how they could use their property, to the point that it becomes useless, that the person can't do nothing with it. They basically devalue the person's property because of all kinds of zoning regulations and building regulations and environmental regulations and all kinds of government red tape, that the owner of the property can actually claim damages. They could seek damages from the government by claiming inverse condemnation. That's basically saying that the municipality, although they did not condemn my property, it's as if they did by creating all this red tape that I can basically do nothing with my property anymore. So you devalued my property because I can't use it. But yet you never paid me or justly compensated me for that. So they could claim inverse condemnation. But it's up to that property owner to prove that all that government's actions have taken the property rights away from them without the compensation. And then they could get a big payout from the government. Because government, sometimes they try all this little trickiness, the red tape that the politicians bury property owners in. All right, everybody got these highlights and the underlines and all that good stuff? Okay. And then here's what it looks like in chapter 6, but you don't have to go there right now. Chapter 6, we're going to highlight the same thing. But look, in here in chapter 6, where they talk about it in a different way. They say, New Jersey law is silent as to the required number of years, although court cases appear to support a minimum of 30 years adverse use, or 60 years if the property is considered woodlands. Well, yeah, that is the case because those laws are on the books, but they didn't mention the 20-year common law. See, the person, whoever wrote this book, does not have the knowledge that I have, because I actually looked it up. And I looked in the court records, the New Jersey legislature. They currently have this still sitting on their legislative docket for the last 17 years to vote on. This is why, this very book has changed it. At one point, one of the versions of the book said the adverse possession period is 20 years. And then another said it was 30 and 60 years. And then another actually said in one chapter 30 years and 60 years, and another chapter said 20 years. Now they changed it to clear it up and say, well, New Jersey's law is silent as to the required number of years. No, it's not. They actually have the number of years stated there. It's just that there's a conflict in the law because the politicians made too many laws that are in conflicting with each other. Okay, so an owner can halt the process specifically by granting permission or take legal action for using or by cutting off the continuous use. Do tacking. Okay, so we'll do this. We'll see the slide again in chapter 6 and we'll highlight it there. It's the same. It's basically the same stuff that you see over here, except over here in chapter 20, they're a little bit clearer on the definition and their explanation. All right. Transfer of a deceased person's property. How do we do that? Well, the title is just a word that means ownership. And how do we transfer ownership when somebody's alive? By a document called a deed. And how do we transfer the ownership of a person's property when they die, after they die? By the last will and testament that they made when they were still alive. When does the transfer of ownership take place? I think I mentioned this to you guys once before. I know I did, actually. Deed is the document used that transfers the ownership, but when does the actual transfer of ownership take place? Because deeds do not need to be dated or signed by a buyer. They just need to be named in the deed. So when actually does the transfer of ownership take place?
Closing? Mortgage?
Upon delivery and acceptance of the deed. Delivery and acceptance is the answer, and you'll need to know that for exams. Upon delivery and acceptance of the deed itself. So, transfer of title is known as devise. The devisor is the person who leaves you their property in a will, and a devisee is the one who was left the property in a will. Testate means that you prepared a will stating how to dispose of your assets after your death. A will has no power until after you die. I could write a will and leave you my property in it. You don't get to take my property, and you have zero interest in my property until I die. But once I die, if I wrote it in my will that I'm leaving it to you, then you get it. But until that happens, can I sell my property still while I'm still alive? Sure. And if I never updated my will, do you gain that property still that I already sold? No, because I don't own it. I don't own it anymore. I sold it while I was alive. So even after you make a will, you should update it if things change in your life. If you sold some of those assets that you said you were going to be leaving to someone. Transfer of title by descent takes effect when you die. Every state has their own laws of descent and distribution specifying who can inherit your assets upon your death when you die intestate. Intestate means you have not prepared a will. It is involuntary transfer because you didn't decide who gets your stuff. It's going according to the law now. Make sure you consult an attorney about making a will and your options. I'm going to tell you guys, if you don't have, anybody here have a will? So that means the majority of you do not have one. Make a will. Anybody here have kids? Anyone here have kids that does not have a will? You need to make a will. After class, pick a blank piece of paper and write one. A handwritten will, it will be valid in the eyes of the law, and it requires no witnesses if it's completely handwritten. Okay? Just make sure you name somebody to be your well, put down on the will your name, your social security number, your birth date. Put down, this is my last will and testament as of what date. This is the only one that I have. And write down somebody who's going to be your executor or executrix. You can name somebody in there. If you don't, the court's going to appoint somebody, and they're going to get awarded 10% of the value of all your assets in order to do that. So some attorney's going to get it. And it's going to be a little bit long and drawn out. Whereas if you do name somebody, it's a lot more streamlined to go through probate. And if you have kids, they will get the stuff a lot sooner. Even though they have a right to it and there's no way they're going to get screwed out of your stuff, it's a more drawn out process. If you have a will stating that they get it, it's more straightforward, and the probate can be done a lot smoother. Okay, the probate process. So I suggest everybody have one. I know we don't like to think of our mortality, but you could step off of a curb and get hit by a bus tomorrow, and things happen, you know. People don't think about their mortality. I know you don't want to think about that someday you're going to die, but we're all going to die, and we have no choice in when that happens or how it happens. Just what was it? Yesterday or the day before in my town, you had a young kid who was, I think it was like 18 years old. He got killed in a motorcycle accident because somebody made a U-turn in front of him and he smashed into the side of them, broadsided him, and he died. So you never know. No matter how young you are, you could go at any time, right? So I know we don't want to think about these things, but especially when you have children, you better. Okay. So how does it work?
Yeah, my father died without a will,
Yeah.
and I remember they said that it had to go through court, and then eventually it was put in me and my brother's name, his property.
But it was a drawn out process and a pain in the
Hmm.
butt, right? Yeah.
Yeah.
So it's a lot smoother process. You could take a blank piece of paper and write it by hand. It's called a holographic will, one that's completely handwritten, and it doesn't require any witnesses whatsoever. If you print one out, you buy the software like Quicken Willmaker or Susie Orman Willmaker or something along those lines that are valid in all 50 states. They ask you questions and guide you through it. They could even make living wills for you. Or you could go to an attorney. It costs a couple $100, or you could just do the software, which is cheaper. It's like $50 for the software, if that, the Willmaker. And then you answer the questions. But if you print it out, it does require two witnesses. However, somebody who serves as a beneficiary in a will can also be a signatory, a witness of the will, right? And then you should get their signatures notarized so that it can be authenticated, and then put it in a safe place where people know where your important stuff is. I remember when my dad died, we knew that he had this briefcase where he kept all of his important stuff in. Nobody knew what was in his briefcase. We just knew it was his important stuff. His important paperwork and stuff was always in that briefcase, right? So when he passed away, we opened up the briefcase and started going through it, found his will and all that, insurance, life insurance policies, all that stuff. You gotta look through. Okay, so here we're just highlighting the term intestate and testate. And legally, when a person dies, title to their real estate immediately passes to their heirs by descent or to the person who is named in the will. However, the will must be probated and all claims against the estate must be satisfied, meaning all debts must be paid, especially any unpaid taxes or claims from creditors. Yes, two things are certain in life: death and taxes. Hell, even when you die, you need to pay your taxes. That's the whole purpose of probate. Make sure that your well, the main purpose of probate, to make sure that your debts, mainly to the government, those taxes have been paid.
Question. If
Yes.
your
Yes.
parent passes away, but they still have an active mortgage, what happens then? Do you continue to pay that mortgage out of pocket until you get ownership to the house? How does that work?
I would, and I would not let them know that my parent died. Otherwise, they're going to tell you that you need to get yourself a loan. And if you can't qualify for one, we may have some issues here. You
Interesting. Yeah.
yeah. So, did they have life insurance? Is that life insurance enough to pay off the mortgage loan? You know, yeah, you got some issues there because you can't just take over their loan
Mm-hmm.
in most cases. Some cases you may, depending on the loan, if it had an alienation clause in it or not. Alienation clause, also known as the due on sale clause in the note, basically says that anytime you transfer the ownership of the property, doesn't matter how it's transferred, even upon death, the loan needs to be paid off in full.
Okay.
So if you can't do that and you can't transfer it in your name, you can't get a new loan to cover that. What is your only other option? Sell it.
Um,
So unfortunately, death gets people to lose their family properties a lot of times. So keep your mouth shut. Don't even tell the lender. You know, are you required to? I don't know. I'm not going to talk to an attorney. Let me not give you any legal advice here. I don't want to give anybody some wrong information or illegal advice or anything like that. I'm just saying what I would do. Okay. Which is actually a conversation. I have since I used to be married, sold my house, got divorced. I moved in with my parents temporarily until I could buy another house. My father passed away, and then my mother guilt tripped me, of course. You're not going to leave your poor old mom all by herself, are you? So now I've been living here with my mother, for quite some time now. And I take care of the house. She appreciates everything. But I told her, I was like, listen, Dad had a will. Do you? Especially since she's getting up there in age now. So we went off to an attorney and we had her write up a will. It's important to have these things addressed, because I have two brothers and sisters as well. So we need to have, she needs to put a will into place, how she wants to dispose of her assets, who she wants to get her stuff, where do you want to be buried. So we actually handle all this stuff. We went and we bought a burial plot for her. We managed to get all that stuff taken care of, have the discussion so she could decide, she could be the decider of it. And we took care of a lot of these things in advance for her, you know. Um, and yeah, it's better to be prepared because you never know. And when you get caught off guard by those things, first of all, the emotional, thing, when you lose a family member, that's horrible. That's going to be horrible on your brain as it is. And then you got to deal with all these other things. It's a lot of stress. So it's better to try to take care of this stuff in advance if you can. And that's what we did. So start thinking about it now. Your did your parents already pass away, or
No, so I have an interesting case where they're in Queens, but my father thought it was a good idea a couple of decades back to buy a two-family house with his friend because they both couldn't afford it alone. So they're joint owners. But
uh,
now I'm wondering if he were to pass away, how much of a quote unquote shit show would it be to get half of the house, or would it go to court and it would have to be sold
but
because one of the owners passed away?
if he doesn't write it in a will, if he doesn't write it in his will, then his rightful heirs can still step forward. You being the child, is there more than one child, or is it only you?
There's four of us.
So four of you would be the rightful heirs to gain his half of the ownership.
Mm-hmm.
Okay. Yeah, that's going to be a pain in the butt.
Yeah.
You're better off getting it in paper uh,
Mm-hmm.
to have that taken care of. Now, so if he passes and he leaves it to you and your other siblings, uh, the loan, as long as it continues to be paid, which I'm assuming it's being paid by the rentals, right? As long as all the bills keep being paid, then it's not much of an issue as far as the mortgage loan goes.
Mm-hmm.
Um, eh, but if the mortgage company, the lender finds out, or they need all the owners to sign documents, and all of a sudden they find out that one of them has died and there's four other people that took half of the ownership, uh, you may have a little issue. Okay? Uh, Consult your attorney. Okay, that's
Yep.
legal advice. And the best way to avoid liability is to advise people to consult with the experts, right? That's an exam question too. What's the best way to avoid liability other than sticking to the truth? Always refer to the expert sources. I'm referring you to an attorney how to deal with that, okay? Yeah, unfortunately, that's the only advice I can give you, really. Sorry. But yeah, it would be a shit show. So, probate or administration is the legal process by which courts determine who inherits the property of a deceased person and what the assets of the estate are. Now, either an executor or executrix named in a will, or an administrator named by a court if no executor or executrix was named or there was no valid will, oversees the administration and distribution of the estates. So once again, we have this with all the players here that I showed you earlier in chapter 5. We also have this here now. Just as a little recap, an heir is the natural blood relative who can inherit the belongings of the relative who died. Devise is to transfer or leave property by will to someone upon death in your will, your last will and testament. Devisor is the person who leaves those things to you in a will, and a devisee is the one named in a will to inherit those things. And they don't necessarily need to be an heir. Demise is a transfer of property by lease, which should not be confused with devise, which is a transfer of property by will upon death. Testate means you made a will. Intestate means you did not. Testator is a man who makes a will. Testatrix is a woman who makes a will. Probate is the court proceeding that determines who the natural heirs are, or to confirm who the devisees are that may have been named in a will of an estate. No matter if you had a will or not, the probate also determines what the assets are after all debts have been paid. And then whatever's left over gets distributed according to your will. An executor is a man, an executrix is a woman that you have as a trusted person that you named in your will to ensure that your final wishes are carried out as you outlined in your will, and how to distribute those assets. If you did not name an executor or an executrix, the court will name an administrator to take on those duties, and they'll probably get 10% of the value of the estate as well. Descent and distribution is the laws that every state has that determines who the natural heirs are that could lay claim to your estate when you die intestate. Escheat is when you die intestate and no heirs can be located. The property then would revert to the state. They'd sell it at auction, keep the funds in a fund for 1 year in which the heirs can claim it, and if they don't, well, the state gets your money to blow as they wish. Do you want the state to get your money? Do you want the state to get your house? Then make a will. Legacy is your personal property you've amassed during your lifetime, and your bequest is your wishes of who you wish to get it. I bequeath to thee my vast fortune of $4 in my bank account. Okay, so that's how you leave it to someone. Dower and courtesy are ancient New Jersey specific rights where dower begins with a doe, and a doe is a deer, a female deer. So dower is the wife's right, and courtesy, because men should be courteous to women, is the husband's right. So these are ancient rights in which a dower is the ancient right in which a wife has certain interest in her husband's death in any real estate he owned during their marriage. Courtesy is that similar right that the husband has in the wife's property that she owned during their marriage. New Jersey abolished the creation of any new dower or courtesy rights as of May 28, 1980. Yes, you need to know that dower is the wife's right, courtesy is the husband's right, and you need to know the date that New Jersey abolished the creation of any new dower or courtesy rights, which is May 28, 1980. If people were married before May 28, 1980, they still have dower and courtesy rights. If they were married after May 28, 1980, marriages after this date, the spouse only has rights of interest in the primary marital residence. And of course, anything you specifically left them in a will. By the way, you guys looked up, did everybody look up, see if they owed money during the lunch break at unclaimedproperty.nj.gov?
I found my mom's name there.
You did. Did it say what it was for?
No, I have to log in with her credentials.
Okay.
So that'll be the weekend trip.
Look at that. That's awesome. Hopefully it's a lot of money and not $13 like Coletta found, right? Well,
Do
then
you use
something else
maiden name?
though, right? I'm sorry?
Maiden name or
Using both. Search them all. Yeah. Search maiden name, search married name, search other states using the missingmoney.com website, but unclaimedproperty.nj.gov is specifically just for New Jersey stuff. New Jersey pulled out of missingmoney.com. But you could still maybe find things in missingmoney.com because some banks may post it there. If it's like something with banking, because there's all kinds of stuff that goes there that are required to be reported if they're not claimed. So good luck with that. Let us know how much it is too.
Will do.
Or approximate. All right. See, the class hopefully is paying for itself for you there. Or for your mom. Help her out. There you go. Now, transfer of title by will. A last will and testament is an instrument made by an owner. Instrument's another word for document. It's a document made by an owner to voluntarily convey title to the owner's property after they die. Remember, a will only takes effect after you die. It has no power until then. So a party who makes a will is known as a testator. Unless you're a female, you're a testatrix. The gift of real property by will is known as devise. And a person who receives real property by will is a devisee. A gift of money or other personal property is a legacy or bequests. And the person receiving that personal property is a legatee. Now, in New Jersey, children can be disinherited, so be good to your parents. Now, let me stop. Don't be good to them just because of that. They're your parents, for crying out loud. You should always be good to your parents. But a surviving spouse is entitled to at least 1/3 of the estate, and the determination of the augmented estate is a complex calculation. In a case where a will does not provide the minimum statutory inheritance, the surviving spouse has the option of informing the court that they'll take the statutory share rather than the lesser share that was provided for in the will. This practice is called the right of election, and it's reserved only for a surviving spouse. So, can your spouse write you out of a will? Can your spouse write you out of their will? Sure they can. I mean, not legally, but sure they can. I mean, anybody can do anything. There's consequences if you're caught, right? Can you kill your neighbor? Sure you can. But you go to jail if you get caught, right? I mean, there's consequences to everything, So anytime you ask a question, can you or could you, that would probably be the answer. Sure. But you really should think about it twice. Now, so a surviving spouse is entitled to 1/3 of your estate. So if your spouse leaves you less than that amount in their will and they die, you could either accept that amount or you could be like, nah, 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 nah. I'm going to take the minimum that you are required to leave me by law, 1/3. That's called the right of election. Now, a will differs from a deed in that a deed conveys a present interest in the real estate during your lifetime by the grantor, while a will conveys no interest in the property until after the death of the testator or testatrix. To be valid, the deed must be delivered during the lifetime of the grantor. Which brings up an interesting thing. I forget who it was, but there was a Motown diva from New Jersey that she sold her property and she died before she was able to deliver the deed. Now, she did the transfer, her attorney, the buyer, and their attorney. They did all the paperwork. They FedExed the paperwork to them. They were signing the paperwork, and they were supposed to FedEx the paperwork back. The buyer wired the funds, and before she was able to deliver the deed in hand, she had a massive stroke and died. So she never delivered the deed. When does the transfer of ownership of real estate take place? Because her children, they wanted to keep the house. And of course, they figured all the money in her bank account was hers. Remember that money that the buyer wired in for the purchase of that house? So she was already in possession of that money, and she was on her way to deliver the deed that she signed. She was on the phone with her attorney, the other attorney, and the buyer. Said, I just signed the deed here. I signed all this paperwork. I put it in a FedEx envelope. I'm bringing it, and I'm going to send it out. And she died on the way. So, did the transfer of ownership take place legally? That was the argument that went before court, because the kids wanted to keep the money and the house. You don't get to keep both. So they were just being greedy. So it's one or the other, but it ended up being the other. They don't get to keep the house because there was the implied delivery and acceptance. It was implied because they even found the documents that she signed that she never got to deliver. But she said on the phone with a conference call between her attorney, the other attorney, and the buyer that this was happening. So there was all those witnesses there too. So the courts actually ruled in favor of the buyer, that he gets the house and the kids got to get out. They get to keep the money that's in the account because she left it to them, but they don't get to keep the house too. So that's an interesting little scenario there too. Now, the parties named in a will have no rights or interest as long as the party who has made the will is still alive. They acquire interest or title only after the owner's death. So here's a chart that we're going to see in chapter 7 about the words that end in OR versus the words that end in EE. These are the easy ways to remember legal terminology that I spoke about before. As long as you know the root word and what it means, like devise, that's a transfer of property by will. So the devisor is the one who gives the product, gives whatever the root word is. They give the whatever's left in the will. And the devisee is the one who receives whatever is named in the will. That's going to be given, right? You transfer the ownership by granting the ownership to somebody else. So the grantor is the person that's giving their or selling their property, and the grantee is the one that's receiving that ownership. Legacy's personal property. Lease is that document where an owner intentionally transfers their property and all their rights to a tenant for a limited period of time. So the lessor is the one who gives the lease, and the lessee is the one who receives it. Now, the mortgage is unique, because you guys know what a mortgage loan is? You guys know what a mortgage is? Don't read the bottom. A mortgage is a promise to pay. It's not a loan. You could have a mortgage loan using both those words together. A mortgage is not money. A mortgage is a promise to pay. banks don't make promises, they make loans. So who is the mortgagor that gives the mortgage? Well, for that, you need to understand what a mortgage is. A mortgage is a promise to pay. It's not the money. There are two parts, the mortgage and the loan. So the mortgage is the promise to pay that the borrower makes to the lender. The borrower says to the lender, if you lend me your money, I agree to pay you back the money according to the terms in the note. If I default and fail to pay you back according to the terms that we've agreed upon, you could foreclose on me, sell the property at auction, and use the proceeds to pay off the debt. That is the promise that's being made in a mortgage. So who's making the promise? Who's the mortgagor that's giving that promise? The borrower. And the mortgagee is the lender. Now, if you want to remember this without having to go through that whole story of remembering that whole sordid details about the mortgage is a promise to pay and banks don't make promises, they make loans. It's the borrower that makes the promise. So therefore the mortgagor is the one that gives the mortgage, and that would be the borrower. And the mortgagee is the one that receives the promise. That would be the lender. Instead of remembering all that, you could also remember that the word mortgage has two O's in it. The word mortgagee has two E's in it, just like lender. Right? Mortgagor has two O's, borrower has two O's, mortgagee has two E's, lender has two E's. Or just remember it's the opposite of what you think it is. All right, because most people get this wrong. Okay, but it makes it easier to understand who the players are. Here, I'm going to give you a better way to remember it. Okay, because remember, I like the KISS concept. Remember what that means? Keep it simple, stupid. Right? I like the simple, stupid method of learning. I don't know about you guys. I like the simple, stupid method. So here's an easy way to remember who the mortgagor is. Are you ready? The mortgagor is the borrower. Yes, we're going to sing. The mortgagor is the borrower. Who's the mortgagor? Borrower. The mortgagor is the borrower. Unfortunately, there's no rhyme for mortgagee and lender. So just remember they're the other person, but the mortgagor is the borrower. Hopefully my annoying voice gets embedded into your heads. And while you take an exam, you're going to get a little chuckle because you're going to see the word mortgagor. And when you're trying to remember and ask yourself who the mortgagor is, you're going to hear my annoying voice in your head singing, the mortgagor is the borrower. Hopefully it works. Okay? Because you may not get a question on exams that specifically just asks a simple question like, who is the mortgagor? I mean, you may, but I doubt it. You'll probably get some long-winded question that has the word mortgage, mortgagor, mortgagee, and all these other terms in it. This is why you need to know all this vocabulary that I'm teaching you, because the questions are going to be loaded with these terms. And if you don't know what the terms mean, you're not going to understand what the question's asking of you. So let's move on. What are the legal requirements of making a will, since so many of you do not have one? Well, a person must be of legal age and sound mind when they execute the will. The drawing of the will must be a voluntary act, free of any undue influence by other people. Any person of sound mind who is 18 years of age or older can make a will devising their real property. All wills must be in writing to be valid. The general rule is that a will must be witnessed by two persons. A beneficiary can serve as a witness in New Jersey. If the signatures of the witnesses are notarized within 2 days, probate proceedings are simplified. A holographic will is a will that is handwritten, signed, and dated by the testator, the person whose will it is. And under New Jersey estate planning law, holographic wills can be probated and will serve to ensure the testator's assets are bequeathed according to the testator's wishes. So, a completely handwritten will is perfectly valid without any witnesses. Make sure you sign and date it, though. And all wills must be in writing to be valid. What does that mean? No video wills. If you do a will and you make a video will, it's not legally valid and enforceable in New Jersey. It has to be in writing. If you wish to, you could have your written will, and then you could sit there reading it on a video camera so that your descendants there can see you reading the will and talking and maybe saying whatever heartfelt thing that you want to say to them for dramatic reasons like you see in the movies. But the video will in itself has no legal force to it. It must be in writing as well. So for real property acquired by a married deceased person before May 28, 1980, that's talking about dower and courtesy rights there, the surviving spouse is still entitled to a life estate of 1/2 interest in all the real estate owned by the deceased, no matter what other provisions were made for in the will. If you were married after May 28, 1980, your spouse is only entitled to 1/3 of the estate, not 1/2. So, title to real estate and personal property of a deceased person who dies intestate without a will passes to their heirs. And under the descent statutes, your primary heirs of the deceased are your spouse, civil partner, or domestic partner, and close blood relatives. Now, when children have been legally adopted, most states consider them to be heirs of the adopting parents, but not heirs of the ancestors of the adopting parents. In other words, the uncles, the grandparents, and so forth. You know, you can't claim to be their family members, even though they may have taken you in and considered you family. You can't legally lay claim to their assets as a family member because you really were not a blood relative. They can leave it to you in a will if they wish to when they die, but you can't lay claim to their assets if they didn't. Now, in most states, illegitimate children, let's stop there. Anyone know what an illegitimate child is? It's when your parents were not married before you were born. Okay, so you are the bastard child. Okay. I know it sounds so mean, but that's the way that they refer to it as. So in most states, illegitimate children inherit from the mother, but not the father. I told you these are some medieval time laws. Illegitimate children, if your father was not married to your mother when you were born, you can inherit from the mother, but not from the father, unless the father admitted you were his child, or parentage has been established in some other way, like through a blood test, through a paternity test. Otherwise, you can't lay claim to even your actual real father to inherit anything from him. Kind of crazy, huh? Now, if he legally adopts his own child after they were born, that child inherits like an adopted child would from the father, but not from his brothers or sisters or parents on his side of the family. Isn't that crazy? We're talking about somebody who's actually a blood relative now. It's just because your parents were not married at the time you were born. This is New Jersey law and how it works. Kind of some medieval time stuff, right? Like it really is like the Game of Thrones, right? No, that guy's the bastard child. He does not have the right to lay claim to the throne. It really is that kind of stuff, right? So,
Someone told me it's mommy's baby, daddy's maybe.
that's cute. But if that's you, that would suck. Right? Okay, so how does it work now? How does the laws of descent and distribution work in New Jersey? Me. Hmm. All right, so intestate real property is distributed according to the laws of the state and where the property is located. And in New Jersey, the laws of descent and distribution provides that the real property belonging to an individual who has died intestate, that means without a will, is distributed in the following order. The law and the estate discussed apply only to what remains of the estate after payments of all debts. It's gone through probate. So, once again, the laws of descent come into play only when the descendant leaves no will. A surviving spouse or partner becomes the sole heir if the descendant leaves no parents or children. You don't need to take notes on this stuff, by the way, guys. This is not on exam. This is just for your own edification, because I get people all the time that ask, well, what happens if you die without a will? Who can get your stuff? Who can lay claim? What's the law in New Jersey? Well, a surviving spouse or partner becomes the sole heir if the descendant leaves no parents or children. If there is a child or children who are also the children of the surviving spouse, the spouse or partner receives the first $50,000 plus 1/2 of the remaining estate. The rest goes to the child or children. If the descendant leaves parents and a spouse but no children, the spouse or partner receives the first $50,000 plus 1/2 the remaining estate, and the rest goes to the parent or parents. Now, what happens if they didn't even leave $50,000? Because in both of these examples, they say the first 50,000. Well, if they don't even have 50,000, well, then the partner receives the full 50,000, and that's it. There's nothing left, right? Now, if there are children who are not children of the surviving spouse, the spouse or partner receives half the estate and the child or children the other half. Where there's no spouse or partner that survive, children become sole natural heirs. But where there are neither a surviving spouse nor children or children's own heirs, the estate first goes to the parents, and failing that, to brothers and sisters or their heirs. In default of any other natural heir, grandparents, aunts, uncles, and first cousins may be considered heirs. Beyond that point, the entire estate goes to the state of New Jersey by escheat. All right, so how does escheat work? Well, the state treasurer sells the property at a public sale, an auction, and they give notice by the publication in a newspaper in Trenton and in the main newspaper in the county where the property is located. The proceeds from that sale of that auction are held in a fund for 1 year, and if no claims are made within the year, the funds belong to the state. They escheated you out of your property. Okay, so one way you could check, they'll post it up in that fund on unclaimedproperty.nj.gov. And for things that are not New Jersey, look at missingmoney.com. New Jersey no longer participates in that one. And that concludes Chapter 20. So let's do the key terms to review for Chapter 20, shall we? So Chapter 20, there's one key terms to review. Next to letter L before we get started here, at the end of it where it says one who can inherit, write blood relatives after that. Blood relative. Actually, it's a blood relative unless we're talking about who are they inheriting from. If they're inheriting from the parents, then it could be adopted children too, but not from ancestors of adopting parents. Oh my God, then it gets into a long drawn out explanation. But blood relative for most part would apply to most situations. So let's just write blood relative there. Okay, person named by the state to administer a descendant's will.
Administrator.
That's an administrator. That's the person that was named by the court because you didn't name somebody in your will. One is A. Court proceeding to establish the validity of a will and to determine what the assets of the estate are after all debts have been paid.
Probate.
10 is B, probate. Title acquired by usage. Simply by using the property, you gain title.
Adverse possession.
Adverse possession.
Yes, 2 is C, adverse possession. Person named in a will to administer a descendant's estate.
Executor.
Executor. You should put there / executrix, because executor is just the man. Executrix if they're a woman. EXECUTRIX. Executrix. 5 was D. Transfer of title without the grantor's consent.
Involuntary alienation.
It is. 8 is E as in Edward. Without having a will.
Intestate.
7 is F. One who makes a will.
Testate.
Testator. Testator. 12 is G. You could put a / there because testator is a man and a woman was a testatrix. So put / testatrix. So 12 is G, testator or testatrix. Document disposing of property after one's death. What's the document that determines how to dispose of one's property after they die?
Last will and
Last will.
testament.
Yep. Last will and testament. 9 is I. Oh, H. 9 is H. Sorry. Having made a will. If you have a will.
Testate.
Testate. 11 is I. Acquiring of property by natural heirs.
Heir.
Voluntary alien.
Acquiring of property by natural heirs. I just showed you every state has a law that dictates how to acquire property by natural heirs when you die without a will. We call that, what was that list called?
This. Descent.
Descent.
Okay.
Descent, yep. Like your descendants. Descent. Descent and distribution. So it's descent. 3 is J. One who receives real property through a will.
Devisee.
Devisee. 4 is K. One who can inherit those blood relatives.
Heir.
An heir. Unless it's from your immediate parents, you could be adopted and inherit from your mother and father, your adopted parents. So 6 is L. Transfer of title with the grantor's consent.
Voluntary alienation.
It's voluntary. It's voluntary alienation. 13 is M, and that concludes chapter 20.